Good morning, Ma'am Anugrah and my friends. My name is Yohanes Christian Kamengyeti with student ID number A00021464 from Faculty of Law Blasmart University. Today, I will explain the civil case carried out by Leeds Property Service and Bukalapak.com Ltd. For more details, let's watch the following videos. Before I discuss further, I want to convey information to you that there are three contents that will be discussed in this PowerPoint, including the first is what is or are the legal issues. Number two, how the case should be solved. Number three, what kind of assessment and judgment that can be given to the case. Next, the question number one, what is or are the legal issues? We will find out on the next page. Next, based on the case that has occurred, it can be analyzed that the legal issue is related to the first is unlawful acts or unrahmatic death, and number two is breach of agreement. This can be proven when the panel of judges legally declares that Legal Property Service Ltd has been legally and convincingly proven that it has abused about the position and has violated the law by not executing the letter of intent between Leeds Property Service Ltd and Harmas Jalas Viva Ltd, date 12 January 2012. After that, the breach of agreement case faced by Leeds Property Service and Bukalapak.com Ltd was proven when each party was unable to pay off its debts amounting 165 billion and 3.12 billion rupiah. Next, the question number two, how the case should be solved. Is the case shall be solved through non-litigation or litigation process? We will find out on the next page. Next, the case currently being faced by Leeds Property Service and Bukalapak.com Ltd must be resolved in the South Jakarta District Court for the classification of unlawful acts or unrahmatic death and breach of agreement. This must be done considering that Leeds Property Service and Bukalapak.com Ltd has violated Article 1365 of the Civil Code, which states that every person who commits an unlawful act is required to replace the loss arising from his unlawful acts, and Article 1338 of the Civil Code, which states that all agreements made in accordance with the laws apply as law to those who make them. The agreement cannot be withdrawn other than by agreement of both parties or for reason determined by law. Approval must be carried out in the good faith. Next, from this explanation, there are four elements that must be proven in connection with this Article 1365 Civil Codes. The first is unlawful acts. This element is fulfilled by Leeds Property Service and Bukalapak.com Ltd. Does not show good faith in terms of completing the obligation to pay the rental fee from the Tower Office 1 Bell Park by unilaterally terminating the lease relationships. Number two, mistake or fault. According to a civil law expert, Rotten, state that every consequence of an unlawful act cannot be held accountable if there is no element of mistake. The element of mistake itself can be classified into two, namely the first, mistake committed intentionally, and the second is mistake due to the carelessness and or negligence. In civil law, both intentional and careless mistake have the same legal consequence. But in this case, the mistake was made by Leeds Property Service and Bukalapak.com Ltd is classified as a willful misconduct. This is evidenced by the fact that the two parties did not show good faith in terms of completing their obligation to Harmas Jalas Viva Ltd as the owner of the building and the rental contract. Next, the third is loss or disadvantage. Losses in civil law can be divided into two classifications, namely the first, material losses, and the second is immaterial losses. Material losses are losses that are actually suffered. What is meant by immaterial losses are losses on benefits or gains that may be received in the future. But in this case, the loss suffered by Harmas Jalas Viva Ltd is classified as immaterial losses. This is evidenced by the loss of the company amounting to 77.5 billion rupiah due to the action taken by two parties. And the fourth is causal relationships between the unlawful acts by the perpetrator and the loss suffered by the victim. The teaching of causality in civil law is to examine the causal relationships between unlawful acts and the loosest causes, so that the perpetrator can be held accountable. This relationship concerns that the losses suffered by the victim as a result of unlawful acts committed by the perpetrator. In this case, this element is fulfilled by the action taken by Leeds Property Service and Bukalapak.com Ltd. in the form of not show good faith in terms of completing their obligation to Harmas Jalasweva Ltd. as the owner of the building and the rental contract so as to make a very big loss. Next, the question number 3. What kind of assessment and judgment that can be given to the case? For example, what punishment, fines, remedy that shall be given to the parties who causes the injuries and loss or damage? We will find out on the next page. Next. Based on the analysis that has been done, the sanction that can be imposed on Leeds Property Service and Bukalapak.com Ltd. in relation with the breach of agreement, there are 3 kinds of sanction. Namely, the first, pay the loss suffered by Harmas Jalasweva Ltd. In the above case, the immaterial and other losses suffered by Harmas Jalasweva Ltd. was 77.5 billion and requests Leeds Property Service Ltd. to return the consulting fee for marketing service of 3.1 billion and pay forced money or duang sum of 30 million per day from the date that the decision is pronounced by the panel of judges. And the second is paying court fees during the trial process in court. In this case, the payment of court fees as a second sanction is aimed at a negligent debtor. This sanction is summarized in a procedural law regulation that the defended party is required to pay court fees. And the last is do a guarantee confiscation. To guarantee that the lawsuit filed by Harmas Jalasweva Ltd. Will not be in vain or illusory in the future, that in this case, the South Jakarta District Court declared legally and confiscated the collateral value of Leeds Property Service Ltd. Shares of 40% of the total accumulated value of the shares, and this action must be taken with the aim of safeguarding the rights of Harmas Jalasweva Ltd. From both parties prior to the judge's decisions, so that the property is not lost. Next. After that, in relation with the unlawful case, referring Article 1365 of the Civil Code about unlawful acts or unpragmatic death, Leeds Property Service and Bukalapak.com Ltd. must pay compensation jointly and severally for immaterial losses and other losses in the amount of 77.5 billion. Next, that's the analysis and presentation that I can convey today. Thank you for your attention. I hope this video is useful for you all. God bless you.